Welcome, everybody. This is Omar Serrano with the Tilted Lawyer. Pause. All right. Welcome, everybody. This is Omar Serrano with the Tilted Lawyer podcast. We have a verdict, and I know, having spoken to a number of you, that many of you guys are horrified at the prospect of this verdict, and I get it. And I think it's important to ask the question about what this verdict represents for all of you, for our country, for our justice system. Because I got to tell you, look, I haven't listened to many of the other lawyers covering this case. I try to stay away from law and crime, mostly because I just can't stand their boilerplate coverage. I've listened to Andrea Burkhart. I've listened to Lawyer Lee. From what I've heard and what I've gathered, every attorney that has had an opinion about this case is of the opinion that this was going to be an acquittal, that this was going to be, at the very least, a mistrial, because we've all been practicing for a number of years. Many of us have done dozens of trials ourselves, tried cases to verdicts with our own juries, and we believe that evidence means things. And I don't know anything about Richard Allen. I don't know nothing about him other than this trial. I believe that the way he was handled runs so counter to your constitutional rights as to suggest that something afoul exists over there, and has so far skewed the justice system that we have a scenario where it has been deemed so far, where it has been deemed fair that you can take a man, exclude evidence pointing elsewhere, introduce evidence that's not proven at court, namely the ballistic evidence, take differing eyewitness accounts and try to make it look like it was pointing towards a certain guy, coerce a confession out of him by throwing him into a maximum security prison for a period of over a year, break him down psychologically to the point where he's confessing to things that he may not have been guilty of. And look, I don't know for sure that he's not guilty. I just know that there are red flags when it comes to his confession that were not answered at trial. And you could convince a jury of 12 under all of those, through a series of judicial determinations made by this judge that fundamentally altered the course of what I believe the jury was allowed to hear in this case, that prevented Richard Allen from having a fair trial, that prevented this jury from being able to render a fair verdict. I don't know. I did a poll last week about what you guys all thought that watched this show and have followed this case, about what you guys thought, given the evidence, the presentation of evidence that you've heard and seen from other lawyers and my show and others the like. Over 80% of you thought that there was enough for reasonable doubt. Many of you said that, well, I don't know if he's innocent or not, but I certainly have reasonable doubt. Very few of you were like, oh, definitively, yeah, he's 100% innocent. Even fewer still were like, oh, yeah, come on, man. Who would confess to something like that if they didn't do it? Because I think that all of you, in the course of listening to this trial, have understood and come to understand what the Reed technique is, why it has been frowned upon for years now, and why the introduction of Reed technique confessions creates immediate appealable issues if that tends to be the primary focus of the state's case against any defendant. Reed technique coerced confessions are not the same as voluntary confessions. There's dozens of Supreme Court cases that speak directly against the Reed technique. that was employed in this case. So look, I got a lot to talk about. There are at least 5 appellate issues that need to be addressed. Because make no mistake about it, I'd be shocked if they haven't already filed their notice of appeal, but this is going to go to appeal. There's 5 specific areas that they have a pretty good shot at an appeal, and I'm going to talk about all of them. So you're going to want to stick around. It's going to be a heavy show. I got a lot to get to. Let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
All right, folks, I'm letting you guys know I got a ton of notes here, and I have a lot that I'm going to be focused on. I may be joined by Watts the Obsession, my friend and friend of the show, Kelly, to share her thoughts. She's been covering this trial as well. But I have a lot of legal stuff that we need to break down because this case, I'm going to explain legally why it represented an unfair trial for Richard Allen. Because of that, I may not have my eye firmly square on the comments. I apologize. I don't have Dominic with me to monitor all that stuff. The best way to get my attention is to drop super chats because it makes a little sound in my ear and it forces me to refocus and make sure that I get your comments in when they do come in. By the way, let me make sure that I have that setting here so that I can hear you guys when you come in. And okay, that'll work. So, all right, folks. Uh-oh. I accidentally, all right, let's get started. So, appellate issue number 1. There's been a lot of discussions and a lot of talk about third-party culpability evidence. I am going to break down exactly what the law states with respect to that. So obviously, the exclusion of it, Richard Allen's defense team is going to argue that it was a significant error that hindered their ability to present a comprehensive case. There's a case that's on point. It's Cam v. State, 908 Northeast 2nd 215, where the Indiana Supreme Court held that excluding evidence of third-party guilt violated the defendant's right to present a complete defense. Similarly, there's another case, Tibbs v. State, 59 Northeast 3D 1005. The court concludes that excluding exculpatory evidence indicating that someone else committed the crime impinged on the defendant's right to present a complete defense. In other words, it's well-established law that if one of the defense strategic maneuvers in presenting their defense is to introduce third-party culpability evidence pointing to other suspects, it's well established. They have every right to do that. The question is, what is the evidentiary standard that would allow the defense to present that evidence? And as you've heard many times, the judge said there has to be a direct link tying something from the crime scene where the incident occurred to some other person. The most obvious example of that I'm sure all of you are aware of is Weber and his white van that people have been talking about for years. There just happened to be this white van that was seen in and around the time that the incident would have taken place that points directly away from Richard Allen to this other guy. It turns out he had some kind of a story, some kind of an alibi that he tried to tell law enforcement at the very beginning. Turns out that story changed after the fact. And when the defense called him out on it, there was like this incendiary exchange between the defense and Weber that I'm sure that everybody is curious about. That would be the most obvious, like, why wasn't this guy investigated? So I'll share my notes with you guys so you guys could sort of read along. I've prepared a bunch, and if my voice ain't doing it for you, you could at least read along as I go through this. And I'm not going to read it all word for word. I'm just going to read the the portions to get through what I need to get through. So here is, oh, I'm sorry, I have to do it like this. There we go. There we go. I think it's up on the screen. Yeah. All right. The evidentiary requirements for introducing third-party culprit evidence in a criminal trial in Indiana are primarily governed by the Indiana Rules of Evidence, particularly Rules 401 and 403, and it appears to me that the Indiana Rules of Evidence tend to mirror the federal Rules of Evidence, which makes it nice because that's kind of what lawyers learn in law school. They learn the federal rules. Evidence is considered relevant under 401 if it has any tendency to make a fact of consequence more or less probable than it would be without the evidence. There's a case on point. There's a couple of them. But if the evidence is relevant, it may be excluded under 403. I lost my place. If its probative value is substantially outweighed by the danger of unfair prejudice. In other words, if the evidence affects the case or is somehow relevant, fine. But if introducing that evidence is so going to prejudice one side or the other that its probative value, the relevance that it would have to the case is outweighed by the prejudice, then the court has every right to exclude it. That is the standard. To admit third-party culprit evidence, the defendant must establish a direct connection between the third party and the crime. The question is, how far of a direct connection do we have to go? Like, do I have to have surveillance video of some other guy committing the crime, smoking gun evidence, something that would make it obvious that there was a direct connection? Or could it be tangential, like there was footprints? Or it turns out that the Google phone that they were relying on to place Richard Allen at the scene was not only used by him, it was used by others. Perhaps other vehicles that pointed to other individuals that would have been present at the incident at the time. Would that be enough? Because that's what the defense was trying to get in, and they weren't allowed to do it. So this direct connection, there was argument back and forth. For whatever reason, the judge shut it all down. And if you can't introduce third-party culpability evidence, and that just so happens to be the primary basis for your defense, it wasn't me, it was some other guy, what in the hell do you expect is going to happen when a jury is supposed to, and they can only evaluate what's admissible? They haven't been presented any viable theory of some other person. They got this guy's confession. And, well, you saw what happened. Guilty verdict. Guilty verdict. Now, listen, I will also say this. It's really easy to attack the jury in this case because we've been talking about all of these things. The jury has not necessarily, they haven't been aware of all of the legal arguments that have been going back and forth between opposing counsels and the judge. They're not aware of the defense's attempts to try to admit this additional evidence. Maybe they'll go home and figure it out today. Maybe that's something that'll happen, but they're basically talking amongst themselves. They're only allowed to discuss the things that they've been told that they can discuss, which is admissible evidence. So they're sitting here, and there's a lot of hemming and hawing and a lot of stuff going on behind the scenes. They're not privy to any of it. And they got these confessions, and they got Richard Allen acting weird on video while he's in prison. What are they to make of that? What are they supposed to do with that information? So I don't want to excoriate the jury for coming back with this verdict because we don't know what they were considering, and I don't even know how the evidence came out. I mean, I've heard impressions of the case from lawyer Lee and Burkhart and all of these others. I have not had the opportunity to analyze specifically what they have been hearing and listening to, and so it's difficult to say. I'm just going to say that it really sucks when there is evidence that exists that directly links others to a crime scene that weren't investigated the same way that Richard Allen was investigated. And you're supposed to be able to put on a defense that shows that he wasn't the guy. All right, well, if it wasn't you, then who was it? I don't know. I can't say because the judge said I'm not allowed to talk about it. What in the hell is that? But that's what happened. That's what happened. Let me get back into this law before I get too far down the rabbit hole. So it must directly link the third party to the crime charged. That's from Joyner v. State, 678 Northeast 2D 386. Now there's some other stuff. In Joyner v. State, the Indiana Supreme Court allowed the introduction of evidence that a third party had an affair with the victim, worked with the victim, had a significant argument with the victim on the day of her disappearance. That would be an obvious example, right? Along with expert testimony linking a hair found at the crime scene to the third party, Smith v. State. By the way, there was DNA found at the crime scene. It belonged to a female, and it didn't belong to Richard Allen. And so it's not like there was nothing. I'm not even sure what the jury was allowed to hear with respect to the DNA evidence. I don't remember. I mean, obviously I wasn't there. I'm relying on secondhand accounts of this. But I know that the DNA evidence that was presented, none of it pointed to Richard Allen. The jury must have at least been able to hear that. And my question then becomes, if that's the case, then why wouldn't they be able to speak to other possibilities? Now, look, there's other evidence. You could talk about the footprints. There was footprints that weren't identified, that were never followed up with. I get it. Random footprints in a place that is visited by the public regularly is not a direct link to anybody. It's a direct link to others, but not to a specific person. The only overarching example of evidence that should have come in, according to my legal opinion, would have been the white van evidence with Weber and asking questions that would have specifically implicated him. Why did his story change? Why this? Why that? Why wasn't he investigated? The defense had a couple of witnesses that were ready to go, that they were going to ask, I suspect, directly questions that would have led to why didn't they follow up with their investigation on Weber, and they weren't allowed to do it. And so they just rested and hoped that whatever they did to rule out the confessions that they knew to be false would have been enough. So that was it. That is the legal standard. And the argument on appeal is going to be specifically, what does this mean? Directly link the third party to the crime charged. How strictly are we going to adhere to this evidence? Like, for example, in this Joyner case, well, all right, so this guy worked with the victim, knew the victim, had a significant argument on the day of her disappearance. That's not directly linking specifically to a crime. That's directly placing him as a person of consequence related to the incident as it occurred at the time, which is not the same thing as smoking gun evidence, which seems to be akin to witnesses identifying a white van that was at the scene when the incident occurred, on the day that it occurred, who had conflicting stories about what he did that day, and perhaps there's something more to that, and the cops should have followed up on those investigations. The jury should have been able to hear that evidence, or at least have an opinion about what they thought. Maybe thought it was nothing. They could have thought that. But the inability to introduce that, a suspicious van at the scene, and the guy not being like any of the other eyewitnesses, this guy had this weird changing story that didn't make a lot of sense, and nobody bothered to follow up on it. If you're trying to, as the defense did in this case, if you're trying to make the argument that the law investigation was shoddy, that would be a key piece of evidence to point to support that argument. The fact that they weren't able to bring that in is an appealable issue. That's going to be the legal fight as it stands to that. Number two, by the way, before I get to that, I want to go over some of my old notes on this case where there was instances of evidence that linked potentially others to the crime. For example, We know that the Fujak email account, the contents of the Google searches associated with the Fujak email account remain unknown. The fact that the defense challenged the state's attempt to introduce that evidence raised questions. The defense was arguing that the state couldn't prove that Allen was the sole user of that account. And at the same time, the state was trying to use that email account as somehow tying into the incident. If you couldn't pin it solely to Allen, how does that even get to come in? But they did let it in. That was allowed in, and it could have potentially implicated others, but the judge didn't allow for that kind of a testimony, to be examined. We talked about Brad Weber. The judge prevented the defense from directly implicating Brad Weber as a suspect. It was disclosed that a handgun was seized from Weber that underwent ballistics analysis. The defense's intention to use that information to challenge the state's firearm analysis suggested that the seized weapon could not be definitively excluded as the source of the unspent bullet. The defense argued that their timeline of events, which placed the van belonging to Weber at the crime scene during a crucial time frame in the state's timeline, would have supported their theory of third-party culpability if they were allowed to present that evidence from Weber's prior police interview. It was excluded. For what? I'm sure when I tell you guys all of that stuff, you would want to delve further into that. What do you mean the guy had a gun? And there is the potential for a chance that the unspent bullet actually belonged to a gun owned by this effing guy Weber. I don't know. Seems like something that you'd want to know. The police investigated, cleared several other suspects. We talked about that a little bit. There was footprints at the crime scene. Again, it's hard to say what that even means if you can't tie a footprint to a direct suspect, but it wasn't allowed to come in. The defense was going to argue that law enforcement didn't thoroughly document who was present, opted not to pursue the footprints lead. That, coupled with their argument that the crime scene was likely not the work of a single person, is a big deal, because you might not, in a multiple person defense, if you're arguing that it could have been multiple people, you're not going to have a singular tie-in to a singular suspect. If you're ignoring the Weber stuff, then fine. All right. But what if it was multiple people? And why would we not be allowed to introduce that evidence in trial? There was a green handkerchief that was recovered from the crime scene that was never tested for DNA. Why? I don't know. But it wasn't allowed to come in. Of the evidence that I'm aware of the defense trying to get in, those are like the biggest. And so that's an obvious appellate issue, right? I mean, just why weren't they allowed to talk about those things? Going back into number 2. Oh, I think I have, I think I have Kelly in the room. Let me get out of this real quick. Hey, Kelly, how you doing?
Hey, I'm doing great. How are you doing? Can you hear me okay?
I can hear you just fine.
Awesome. Great. It's great to see you. Thanks for having me on.
I dig the mic, by the way.
Thank you. And the wet hair, I told you, it's Veterans Day, as y'all probably know, here in the United States. And thank you for all of the veterans who have served for our country. I appreciate that so very much. So in New York, we pretty much closed down on Veterans Day. So I had the day off today. So I was
supposed to have the day off today, and then this happened. And so, well, here I am.
And then you said,
go ahead. Oh, I did. I got a text from Kelly earlier, and I was like, I don't know, I was like in this quiet place, and then I said, hey, so the verdict came in? She's like, yeah. I was like, what was it? Guilty. I was like, fuck. Yeah. It's like
unreal.
Yeah, let me get to some of these super chats before I forget. Okay. Iron Rabbit, thank you so much for the 1-month membership. Iron Rabbit has been around for a while. She gifted 5 Tilted Lawyer memberships to unsuspecting listeners that may or may not be in the chat. Oh, you never know. Starcasm, thank you so much for the 10. Telling me that Kelly's going to be joining in 10 to 15, and sure enough, here you are.
Here I am.
Julie with the 2 says the state needs less than a defendant with third party. Needs less than a... Yeah, well, my understanding of what is required is any evidence that tends to implicate any other person that you could tie into the incident. Out of an abundance of caution, you're going to let that in.
Mm-hmm.
With Weber, it was wild. You have his van there. You have him give a story initially to law enforcement that changes after the fact.
Right.
You have him owning a gun that would have accepted the ammunition that was found at the scene, and the realization that the ballistics
Same model of gun.
It could have came from his weapon.
Yeah,
So
it was
what
a
the
same
F?
tower, same model.
Do you mean that we don't have a direct link? Why was it not let in? I don't get it.
Yeah, I've been listening to everything you said. And as we were talking about earlier with, the Judge Gall, omitting so much, what I believe, it sounds like you believe and a lot of people believe, to be critical evidence into this trial. I mean, she omitted so much. And, I was saying to Omar earlier, he's the one who's a practicing attorney. I just, try to figure this stuff out. But I thought that I thought it was a federal law that you can use, third party culpability or however it be worded as a defense. I've never heard of that not being allowed in if there is any semblance of evidence to prove that third party involvement or culpability does in fact exist.
Well, I think that the reason why you see so many lawyers getting upset with this case is because we all practice. I know what third-party culpability evidence is. I know what it means. I know what it would mean to me in my case. And if you were to ask my opinion about, hey, are we going to be able to get this evidence in about Weber and the white van? Of course we are. Right. It was found at the scene. He's got a similar firearm that could have housed the unspent ammunition. He's in.
Right.
That's in. And I would have relied on that heavily in my defense. And the fact that the judge would have just pulled a 180, he's like, no, it's not coming in. What do you mean it's not coming in? It's not a direct link. What do you mean it's not a direct link? The van was effing there the day of. There's eyewitnesses that saw the van
into the trial. You're allowing all of that in, which probably confused the jury a bit and raised doubts in their mind. So why does that stop right there? Like, if you're going to let that in, let's continue the story of who was driving the white van. What's his deal? Like, how could she arbitrarily determine the stopping points for what was allowed into evidence in the trial?
That's the question. And so that's the big obvious appealable issue. The standard is going to be her abuse of discretion. I don't know of many judges, and I've been practicing for 11 years. It's not as long as some, but it's long enough to know that I don't know of any judges that would have excluded that. Yeah. Most judges, when you bring up there's issues with evidence and we don't know, have a definitive answer, fuck it, let it in. What are we going to do? Let it in. Let the jury see everything. What's the danger? Weber's not the one on trial, but if there is potentially he could have been a suspect, the defense has identified that very early on in proceedings, let it in. Because you know that you're going to be brought up on appeal. I don't know, man. It just, it's infuriating to go through the practice of relitigating it here because it doesn't make sense.
It doesn't.
And nobody's made it make sense to me.
Among other third, party possible evidence that wasn't let in was that whole odinous theory. And, when I first heard it, I mean, I'll be honest, I just almost didn't even want to read about it. Some people sent me links to the, what would be that Baldwin and Rosie filed. It was like 134 pages, 30 or 40 pages. I can't think of that would be called legally, but, where they outlaid their whole theory of possible odinous involvement and odinous culpability for this crime. But when I started to read it, I was kind of like, damn, like this makes so much more sense than I thought. And I actually just today, for the first time, I was telling Honey Bun, who's one of our moderators over at What's the Obsession, hey, thanks for coming over. We were just talking about the too. Yeah, she's great. She's going to come up on panel tonight too. I hope you can make it, Omar. Honey Bun's going to come up. She always has great things to interview.
I'm going to be in there in some capacity for sure. I promise I will.
Thank you. I appreciate that. But, I, for the first time today, saw the crime scene photos that were leaked. Have you seen those, Omar?
I have not.
Do you want to see them or not?
I mean, I'd rather not, but I feel like if it has scholastic merit, I probably should.
Well, see, that's how I felt. The first time they kind of went around, a few people had messaged me with those attachments, and I didn't want to see them. So after the verdict came out today, I did want to see them. I went and looked for them, couldn't find them. My friend Rachel, who's a great research, found them. The reason that I wanted to see them now, whereas I did not before, is I wanted to see, people have talked about, the branches or the sticks that were
Yeah.
laid over the girls' bodies.
Right.
And, the argument, for Richard Allen's innocence or non-involvement is, they were laid there intentional. That is not arbitrary, the way they were laid out. It's not like somebody either was trying to cover up the bodies with them. When I saw them today, I was like, oh my God. I mean, they are
Was
so
it like the Blair Witch style, like
yes, it was. They
some
were
kind of a pose?
so intentionally laid over, like Libby's arm is like, one of her arms is kind of like this, and there's a giant branch that goes right over like her rotator cuff, almost as like to pin her down in that position. And then there's large branches that are laid on her that make a very clear triangular shape. And the same on App. I mean, it is just so incredibly obvious. And I believe that the jurors did see those photos. So I'm sure it had to cross the minds of at least one or two or maybe more of them.
What was that about?
That's so weird. Why are they placed on the girls like that? That's
Hey,
not
by the
arbitrary.
way, that triangular shape that you see the sticks in, it just so happens to be a prominent symbol in this other group that may have been involved. I remember the defense attorneys, when they were getting involved with this case, like the deeper they got in, they had limited access to Richard Allen, and they started to get freaked out. I was like, I'm starting to see all these Odin people. Like they were working at the prison, at the correctional facility. They were in the courtroom with them.
Patches.
The dude was legit like shook. He was just like, I don't know what's going on over here, but something's not right. The defense, he said this like months ago. And then I was like, wow, how ain't that something? When I spoke out, I didn't speak out against anybody. I like basically Googled what is this Odin group, and I started reading about it, and I got emails from actual Odin members. We are not a cult. We are a legit religious organization that's been around since the 1700s. Well, excuse me, I had no idea. But there were people that were offended.
Groups have picked up their traditions and their rituals and their names to do what they're doing, under
Wouldn't be the first time.
Yeah. And I mean, that's a very common practice. I mean, extremist groups, of horrible people like white supremacists will do that. They will want to fly under the radar, under the guise of some group that is just spiritual and is honoring nature and worshiping the earth. No, nobody who's a white supremacist is doing that.
By the way, Julie says, if a defendant has to link directly, shouldn't that be the police's job? Well, the problem is, and oftentimes when you have a defendant that is the prime suspect, the argument is going to be, well, yeah, it should be their job, but they didn't do it, but they should have done it. So this was here, nobody looked into it. That's the reasoning behind third-party culprit theories. That's why you have to have some evidence, so that way you cannot just question the potential suspect, so that you could directly question law enforcement. It's like, bro, you knew that this guy had a gun, right? And you know that unspent bullet that you were so impressed came from Richard Allen's gun. Isn't it true that it also would have fit in this other gun that belongs to this guy Weber? Why didn't you investigate the white van at the scene? Didn't you know there was multiple eyewitnesses that put the van there at the time of the incident? Why wasn't he investigated? Oh, you did investigate him. He gave you a story, right? Were you aware that he changed his story after the fact? Why didn't you follow up with him on that? Why were you so fixated on Richard Allen? What was the deal? And so you're supposed to be able to ask those questions, but you can't if the judge shuts it all down.
That's right.
And
Weber's neighbor, where they lived, apparently it was described during the trial as, I watched all the channels that were there live. Lawyer Lee, I watched like every day. I watch Andrea and Bob Mata and whoever else was there. I wanted to take in all perspectives. Yeah. But there was on the road that Weber lived on, it was more like kind of a dirt road path, and there was only two houses. And his neighbor, the one of two houses that were down that way, that where you would actually drive down that dirt road path where the van was apparently seen, was his next door neighbor, who testified in court saying at 8:30 that morning, she specifically remembered, because it was so bizarre and alarming, that there was some strange guy standing out by the mailbox. And she went and got her husband and said, honey, do you know that weird guy out by the mailbox? And so the neighbors, the one of two neighbors down that dirt road path early that morning before the crimes were committed, already said, things were amiss. Strange things were going on. I was already alarmed by what was happening in my area before the girls were even abducted. So just to the point of what you're saying, how could that not all be let in? So much that was highly suspicious that would make you turn your head in the direction of Brad Weber.
I don't know. Maybe the judge thought it was too prejudicial to the state, which of course it would have been, because it suggests other people.
Right.
It suggests that Allen must not have been the guy. So, it's infuriating. Like I said, it's infuriating to try to go through this exercise of like why this it so obviously should have been left in. Just the fact that you're talking that way, some of that stuff, if the jury hears any of those things, it immediately raises doubt.
Sure.
Why wasn't that followed up on? But if you don't allow it in, it means that Richard Allen, because you got to take this from the perspective of the jury, they're not allowed to ask any of those questions because they don't know any of it.
Right.
And so to them, Richard Allen is the only guy and has been the only guy, and you got some bullshit confession, right? Now, if you're not going to find him guilty, you have to believe that the Reed technique is this coercive interrogation technique that is too prone to false confessions to be reliable, and that has to be the main source of reasonable doubt, which is not fair.
Right.
When if I were to tell you all this other stuff, you would have significantly more doubt, because look, maybe it has, maybe it hasn't. There was not any evidence that suggested that the Reed technique has been outlawed. It is a method of interrogation that some people use. Some people don't like it and others do.
It was used in the Watts case.
Yes, it was. So what are you going to do with that, man? It doesn't invalidate the confession just by bringing up Reed technique. All right, so appealable issue number 2, the composite sketches. So there was composite sketches of bridge guy, of eyewitness testimony, and you know what? I don't think that any of those composite sketches ever implicated Richard Allen directly. No. They just didn't. I wrote the exclusion of composite sketches in Richard Allen's case is an appealable issue. The judge ruled the sketches inadmissible as hearsay and potentially prejudicial. Prejudicial to who? To the state, because it shows that Allen might not have been the guy? Under what scenario is it prejudicial?
What is her definition of prejudicial? That's what I want to know.
Anything that's bad for the state.
Right. If it's a bummer for the state, it's prejudicial under the law.
Yeah.
No.
Look, that's that you wanted to make them inadmissible on hearsay, fine. But they could have got in a hearsay exception. But they didn't. There's a state. There's a case in Roe v. State. The Indiana Supreme Court addressed the issue of hearsay in the context of a police sketch, defining hearsay as an out-of-court statement offered to prove the truth of the matter asserted, which relies on the credibility of the out-of-court declarant. The court emphasized that hearsay is generally excluded because the declarant is not under oath, not subject to confrontation, not available for cross-examination. Additionally, in Strong v. State, the court ruled that a composite sketch made under hypnosis was inadmissible due to its inherent unreliability. That's not talking about the Richard Allen case, it's the Strong v. State case. At any rate, the court noted that the potential for prejudice might outweigh the minimal relevance leading to the exclusion of evidence. The principle supports the judge's decision in Allen's case to exclude. The defense's argument regarding the relevance of the sketches to the bridge guy identification could be considered on appeal. The appellate court would review whether the trial court abused its discretion in excluding that evidence, as appellate courts afford wide discretion to trial courts in evidentiary rulings, according to Beasley v. States. So while the exclusion of the composite sketches aligns with their hearsay rules, it still remains an appealable issue, because the question is, there were hearsay exceptions where they could have got it in. And furthermore, if they're excluding it and under whatever level they wanted to exclude this because it was prejudicial, that to me is a directly appealable issue, because those composite sketches could also be considered direct links to other possible culprits.
Absolutely.
I mean, I guess you can say that, sure, composite sketches, they're historically not reliable, right? They're historically not reliable. Most of the time you get these sketches is to give you your mind's eye, some kind of idea of a concept of who the suspect was. The defense's point was always going to be that none of the sketches resembled Richard Allen. They resembled other people. In other words, what people thought of when they saw these eyewitness accounts was some other guy. And by the way, Bridge Guy is the only incontroverted recording of who this Bridge Guy was. Everybody believes that that's the killer. To me, Richard Allen doesn't look like Bridge Guy. But by the way, some of the sketches sort of kind of do.
Mm-hmm. And there was actually one thing we learned in the trial, I learned this on Lawyer Lee's channel, was that there were actually 4 composite sketches created along the way. I was just looking for the pictures, but I couldn't find them. And none of them looked alike. Sketch number 1
No, they're all over the place.
Was put out to the public. And, you know, and in public, we beseech you to look for this person that is depicted in this composite sketch. I mean, when you're talking about the declarant being reliable or not, you know, I think they in the case law you were just reading, I think the declarant is referring to the person who was a witness, who gave them the information that had the sketch made, but I wasn't clear on that. But I mean, the superintendent.
They would have just brought in the person. Yeah. The hearsay, it would have been brought in by the person that drew the sketch.
Okay.
They already had the eyewitnesses that they relied upon to draw those sketches. I think one of the sketches was done under hypnosis. I can understand. Okay, fine. Don't let that one in because that's weird. You were hypnotized and you drew a sketch, fine. But not all of them were like that. You could have brought the author of the sketch in to testify what they relied upon when they were making the sketch, their artistic prowess. Give me an example of an accurate composite sketch that you get. Give me an example of an inaccurate one. And we could have, but then we're kind of getting into a gray area. It's like, okay, but the sketches are not the ones on trial. That one is a weaker appellate issue than obviously the big 2. And you know, the other one that I'm going to get to, which is going to be the admission of the confessions. And so appellate issue 3 is the validity of Allen's confession. Obviously, the defense argues that his mental state during solitary confinement rendered his confessions coerced or unreliable. And that evidence got in. The question is going to be is whether or not they should have been let in. In Smith v. State, the Indiana Supreme Court considered factors such as police coercion, lengthened conditions of the interrogation, the defendant's mental state. Very famously, Making of a Murderer, Brendan Dassey had to deal with this issue. They used the Reed technique on that guy. Yeah. He was 16 years old at the time.
With a very low IQ, had a number of learning disabilities. Right.
I think they said his IQ left him barely functionable.
Yeah, his IQ was his IQ. For those of you who don't know, because I want to speak to this issue of the confession a little bit. I used to be a special education teacher, and I am now a behavioral therapist. Yeah. And so I have very strong feelings about that. But I do know in that specific case, his IQ was underneath a level that we would legally consider what has traditionally been called mental retardation.
Yeah, something like 82, I think it was. Mm-hmm. It might have been, I don't know, that number's sticking out of my head, but it was low. And the kid was, he was talking about he wants to go back home. He wants to watch WWF. He looked like a kid that was getting yelled at by his parents. I don't know, man. But it went on for a number of times. He had a defense attorney in his case that allowed him to be interrogated a second time. It looked to me, and watching that documentary, that they were planting ideas in this kid's head. There was multiple instances where it turns out that the psychologist that he made a confession to happened to be a true crime junkie. She was familiar with this case. Oh my gosh. And she knew things about the case that, some of the general public might not have known just by virtue of her own. She was
members of several of the different, discussion groups. Some of you all follow true crime. And by the way, my chat isn't working. So there's some things I wanted to say to you guys as you're asking questions, but my chat's not working. Hey, Justice A through Z. So she was a member of several of those Facebook discussion groups specifically about the Richard Allen case. And she testified to the fact that she became members of those groups after she was assigned to him being her client. So she was looking to gather information outside of her discussions with him about him. And I think specifically where she could be problematic is what we were just talking about with the issue of the white van. Is that being something that he brought up that possibly only the killer would know? Did she just flippantly say while he's talking, as people are discussing this case, actually, it's not a big deal. Maybe there's a lot of people that have mentioned white vans because there were. because there was a creepy white
Very
van
good.
trolling in the area recently that was giving candy to children. It was like your archetypal creepy white van.
Creepy white
tries,
man. Yeah.
tries to bait in children with candy. And that what, according to local people, that is a fact. So, I mean, her involvement in those discussion groups and whatnot, I think is highly problematic.
Well, if she dropped, that was their big example of a detail that Richard Allen knew that would have only been known to him because he was the killer, right?
Right.
But they've been talking about the white van on Reddit for like years.
Yeah.
Like going all the way back to 2018 or 19 or whenever this happened. You follow those Reddit threads on the Delphi case. There's mentions all over the place about the white van.
I actually went back through some of the archived, like the Reddit and Facebook and other discussion group posts that I was checking out way long ago, even before I had this channel, shortly after the crime was committed. And there is tons of conjecture about vans, or specifically white vans. I promise you, I can show it all to you guys. It's there. It exists.
Yeah. No, it is. It's there. Pam says, Kelly beat me to telling Omar the verdict. We must have been
sorry about that.
texting furiously. All bullshit in my opinion on the verdict. Yeah, I agree. I was I let out an audible fuck. You're kidding. Oh, it was a lot loud. It was louder than I wanted it to be. In any rate. Thank you again, Pam, for the 5, and then another 5. Oh, did I already get that one? I did get that one. Pam asks, why turn down FBI assistance?
Right.
And the FBI agent who interviewed Brad Weber was not allowed in for the defense. My bigger question was, why did the FBI allow themselves to get turned down by the states?
I agree with you on that, because they don't have to. And there's many instances where they did not allow that to happen. No, we are taking over, and they have every right to do that. And basically any instance when a crime is committed in this country, right?
They could take over if they wanted to. And more importantly, they could have been now, my honest opinion when I first heard about FBI involvement was that they were investigating potentially a RICO case related to the Odinist theory of stuff. It's like, it must be something like that. Like, why else would they get involved? Maybe they thought there was corruption because the Odinists had infiltrated law enforcement or whatever, and they were looking deeper into it. So when they were just like hand waved away, it's like, huh. So it must not have been like that exciting. It must not have been all that important, I guess. But my initial thoughts were it must have been something like that. Mm-hmm. But then they just left it alone. I don't know, man. I don't know.
And since when does the FBI do that? We want you to go away, FBI. Okay, yep, see you later.
I've never heard of that. Yeah, with the FBI in it's funny. I used to, one of my law professors worked for the feds, and then she referred to like the states folks as like the village people. They're like they're the little people down there. They like look down. Like there's like this classism that goes on with the feds and the state and all this kind of stuff.
And that's the overarching view within the obvious. Nobody hesitates to say so.
Yeah. Pam says no witnesses identified as bridge guy. Yeah.
Right. Great
they couldn't
point.
Even identify
Nobody has made that connection. Nobody sat there on the stand and was asked a question or made the assertion, do you see bridge guy in this room? Those moments where, can you point to bridge guy? Yes, he's the gentleman over there in the defendant's table wearing da-da. There was nothing like that. Nobody anywhere ever made that connection. And such a good point, Sarcasm, connecting bridge guy and Richard Allen being able to make that positive identification or even that implication.
Yeah. And so, I don't know what this means. Walla only joined only ones that found him guilty. What does that mean?
Walla, the psychologist only joined the Facebook discussion group that were leaning towards his guilt.
Well, yeah, she was clearly a true crime fan, and she was embarrassed to admit that on the stand. And then they just let her testimony just stand. And I guess they got to question her about it, fine. But just the fact that she was one of the state's experts that was so obviously colored by this case.
Yeah.
Among many different things that we could point to. But let me get back to some of this other case law about false confessions. We talked about the Dassey thing. So basically, this appellate issue is not so reliant on evidence that didn't come in. It's whether or not the evidence should have been excluded, because it would have presented unfair prejudice to Richard Allen. Because obviously, you take this away, then what else do they have? They got nothing. A purely circumstantial case without a confession. Good luck with that. And then the circumstantial evidence wasn't even that great. So where did I leave off? So Indiana law requires that the trial court consider the totality of the circumstances when determining the voluntariness of a confession, including the defendant's mental state and any potential coercion by police. There's a state on point, a case, Pruitt versus State, Stevens versus State, Smith versus State. If the trial court excluded evidence that could demonstrate the involuntariness or unreliability of Allen's confession, this could be grounds for an appeal. And I'm not so sure that that's even going to be the issue here, because the defense got, as far as I'm aware, most of their evidence that they wanted to get in about the mental degradation of Richard Allen and how he progressed. What they didn't get to introduce was all of the evidence. Like they had videos that they wanted to introduce in their case in chief that demonstrated what he was like when he came in versus what he was like at the time of his confessions, and they were limited in what they could give to the jury. So if you're trying to introduce it for the purpose of giving the jury a benchmark for this is what he is when he's normal, and this is what he looks like after 13 months of maximum security solitary confinement, don't you think that the jury should know that?
Absolutely. And I think
under
it's
one
horrible that they didn't. And I think that the one psychiatrist that they had to take the stand, and this is a man whose work is a behavioral therapist I have read about before. It's highly regarded in the field, talking about how false memories are made. And
yes.
it will begin with a statement like, I think that, or it might have been, I think it could have been, which when you look at Lawyer Lee did a really remarkable timeline of all of his confessions. I thought it was pretty tight. She included, I think, everything that should have been. His initial confessions all started out just like that. It followed literally the theory that the psychiatrist, that highly educated psychiatrist and studied and regarded, put forth about the creation of false memories. And other things that were relevant were the circumstances under which it happened, where there's a state of severe stress, anxiety, and pressure. All of that was present. It was a textbook example of somebody creating false memories for the sake of perceived self-preservation.
I don't know, man. The circumstances where the confession was, where it's not even that it was coerced. It was beaten into him over a period of time.
Right.
I mean, just the fact that you arrest somebody 99% of the time, or 100% of the time in my cases, you're sent to county jail. You got the ability to make phone calls. You can call your attorney whenever you want, for the most part, every day if you need to. You have access to family visits and all these other things. You're around other inmates, but they're not putting you in a maximum security, isolated hold.
I haven't heard anybody who's been able to come up with an example of somebody who was arrested and before their trial, they were sitting there awaiting the trial in a maximum security prison. It's absolutely unheard of. It's barbaric, in my opinion.
No, and as the defense attorneys were talking about at the very beginning of trials, like they couldn't even meet with the guy properly.
Right.
Like they sat there and like it was like this weird cell, and like usually when you sit there, like you got a chair and he's got a chair and you're surrounded by or separated by a window, and you could pass papers back and forth and, you know, have a meaningful communication. They were like 5 yards away from him. They couldn't pass papers back and forth. They were talking through like this slit in the door. They couldn't even really barely see him. It was like this ridiculously strenuous task just to have a conversation with the guy. They could barely meaningfully prepare for trial and all of those things. And so, I don't know, man. I just feel that the issue is not so much that evidence didn't come in to the case that would have given the jury information that this wasn't a good confession. My argument, and the argument that's going to be on appeal, is that the evidence should never have the confessions should never have come in the first place.
I agree.
Because of all of these other issues that we have, and we got plenty of state law that identifies what a bad confession is, or when a confession is not reliable. All that evidence and all that case law has already been argued over. The judge made decisions, and she let it in anyway. Inexplicably letting it in without letting in some of the other stuff that we had talked about. That's going to be what the issue is on appeal. And so it's a little bit different than some of the other stuff. One thing that I did want to talk about was this one issue that there were certain phone calls and jail surveillance that the defense wanted to introduce that was made shortly after Allen was arrested, where he had called his parents, professing his innocence, expressing feelings of mental distress. The judge makes this ruling stating that the defense could not introduce this call without putting Allen on the stand, which they were not willing to do for obvious reasons. So the defense attempts to introduce a 30-minute jail surveillance video depicting Allen's behavior, arguing that it was relevant to his mental state. The judge reviews it in chambers, ultimately sustains the state's objections, barring its admission. And essentially, without going through all of this case law that says why that is and why you could do that, the question really becomes, I'm not so sure that they're going to win this one on appeal, but it's something that needs to be brought up. Because if you're talking about whether or not he got a fair trial, the state, as far as I'm aware, had been allowed to introduce a number of different pieces of evidence without expert validation. Just here's a bunch of Google searches. They give it to the jury. Here, look at that.
That I did while I was just on the break. Remember that? I did about the phone. That's a whole, we'll talk about that on my channel because that's one of my biggest issues. But yeah, it was crazy. So much was let in.
So they let that in, say, okay, fine. But when Richard Allen wants to do it, when it's not even like, oh, we don't have an opportunity to cross-examine, you don't need to. It is a video recording of a conversation that he was having that was recorded. There's no need to cross-examine him on it. You are allowing evidence of his confession without forcing him to testify. So we can't go the other route and introduce evidence where actually he said he was innocent. Yeah, it speaks for itself. Yeah. What are we cross-examining?
Right.
The evidence the video speaks for itself. He said this stuff not because he's trying to argue some other bullshit point, whatever. You could ask whatever question, whatever you want, but in the same spirit that you're going to allow his videotaped confessions and as evidence without his testimony, then the defense should have been at the very least able to admit this video of his behavior in this phone call that he was having where he says specifically, I didn't do it. Yeah. But they didn't. They said, well, if you want it to come in, they're going to have to testify, which bullshit, because the guy might not have been in any mental state to be able to withstand strict cross-examination. He might have crumbled on the stand. He might have started going into, he's already given false confessions according to his defense team. Why in the hell will we put him on the stand?
And you know what's so important about what you're saying right now is not allowing that in. And a number of people, of course, we haven't heard from the jurors yet, but just as I've been watching the coverage on this case, you know, a number of people have said, I know like lawyer Lee said, that the most compelling piece of evidence in her mind towards his guilt, you know, and I don't think that she was thinking that this verdict was going to come down whatsoever, but I don't know, you can hear from her, but was the conversation that they listened to with his mother, you know, and a number of people have remarked that that was the one thing that made them think, you know what, that sounded really authentic to me. Those words that he said to his mother sounded truthful to me. It just came off to me as that made me think that maybe that confession was sincere. So they put that in, and that has such influence over the way people are thinking about his innocence or guilt, yet they won't admit what you're talking about right now, which is a conversation with the same person. And
you know, it's funny. People authenticate those kinds of things very subjectively. Mm-hmm. Like you could listen to that and I could hear it and say, well, the guy is, you know, whatever I think, right? The point is that they're introducing stuff like that They're letting that stuff come in, but they're not letting this other stuff come in. Oh, because he's got to testify. How is that fair?
Yeah.
And I'm willing to venture a guess that if I were allowed time to brief this issue, I could probably find case law that states that if you're going to introduce videotape recordings of his conversations admitting guilt, and there's videotape recordings of him not admitting guilt, matter of fact, doing the opposite, then you're not allowed to exclude that evidence, stating essentially that he must testify in order for it to come in. That doesn't make any logical sense.
I bet the ranch you're right about that.
Now, in the 15 minutes in prepping for this case, I was able to find that case law. But I'd venture to guess that that might be something on appeal, where that might be a tribal issue. I guess the question then becomes, would that have been enough to get an acquittal in this case? I don't know if that's enough. But other than that, they could, I guess, appeal on the reliability of the ballistics analytics. If it was so unreliable as they said at trial, then why was it allowed to come in at all? But then even then, it's like, well, that would have tended to help the defense's case then, right? Probably. So that's kind of a weaker appellate issue.
Well, that's the only thing they had connecting him to the crime. The only thing they had was that ballistics info.
Yeah, which I thought was probably some of the best evidence that the defense had. That it wasn't him, that the state was full of shit. They weren't following through on legit leads and all that kind of stuff. Handling of evidence and witness testimony could be scrutinized for inconsistencies, but whatever to that. Maybe. Look, I think the biggest issues are these top four. I promised 5. I mean, this 5th one is sort of kind of maybe an appellate issue, but not really. I think where this appeal is going to be won or lost is on issues 4, excluding the phone calls and surveillance footage of him coming in to the prison that would have documented his mental state from the beginning to when he gave his confessions. And only allowing it by forcing him to waive his Fifth Amendment rights against self-incrimination. I thought that was bullshit.
Omar, could you just go through and kind of just really quickly bullet point what you think those 5 appellate issues are? I'm taking notes.
Oh yeah. So I have exclusion of third-party culpability evidence.
Okay.
Not allowing the composite sketches to come in. That's kind of a weaker appellate issue, but it is a appellate issue. Number 3, obviously the validity of his confessions, whether or not they should have been let in at all, given everything that we know about the confessions and the context surrounding the confessions.
Right.
Number 4, excluding phone calls and jail surveillance, showing him at the very beginning, denying confessing to anything, denying his guilt. Showing his mental state and how it deteriorated from the very beginning until when he gave his final confession. And then if you wanted to put 5, I guess you could talk about why was the ballistics even allowed to come in, whether or not that had a prejudicial effect on the jury, which I don't think that it did. I think that would have been more in the defense's favor, but it is a 5th. If there's a catch-all, 6, which would just be the way that evidence was handled in this case, the way that witnesses were handled in this case, the way that the judge appeared to be biased towards the state in this case could by itself become
throwing the attorneys off the case. No, you can't have your attorneys.
Yeah, that by itself just could generally be a 6th potential appellate issue.
Mind.
Yeah, so those are the 6. Now I suspect, obviously I'm not the defense attorney writing the appellate brief. I just suspect that that's what we're focusing on, and I'm guessing that the actual appellate brief is probably going to focus on numbers 1, numbers 3, and 4, and probably a little bit of 5 and 6. Dang. So we'll see. There's plenty of ammunition for appeal in this case. We'll just, we'll have to see how this goes. Pam says, I learned from this case, no one will ever see something or say something to the police.
That is a damn shame. That is a terrible shame.
Of what value is it to talk to the police when, if you believe that Richard Allen was innocent, you now have to live in a world where you have to accept that if the cops want to paint you a certain way, then they will. And they will throw you in prison. Yeah. Hey, you're not free to go. You're going to jail. I'm going to jail. Shit. And then what if they put you in solitary confinement and then just grill you for the next however many months and coerce you into a false confession. I've been saying up and down that, look, there's a lot of people say, I don't understand how people make these false confessions. I would never admit to doing something that I didn't do. Yeah.
13 months of solitary confinement. We can't even begin to imagine that.
The longest I've ever spent inside of a jail, and when I was visiting one of my clients, was like 4 hours. I gotta tell you, man, I was disoriented in there. Like the air is so heavy, like the walls, the atmosphere is so heavy and dark and damp and depressing, and you get so bored because they don't let you take your cell phone in there. So you're sitting in there for like 30, 45 minutes, an hour, waiting for them to bring your client, just like doodling on paper.
And then imagine knowing you can't leave at your own will.
No, because they got to open
those other layers.
They got to unlock the doors for you and let you in and let you out. And so you can't just leave when you want. You're stuck in there. What if the power goes out? Then it's like, well, shit, I'm just like buried in this like a freaking jail cell, like however many layers deep of concrete and steel. It sucks, man. Like you could lose your mind very quickly. I could see it happening very quickly. Months at a time. It's a lot, man. It is a lot. So, hey, that is the verdict. I don't agree with it. And I'm really disappointed. I'm really disappointed. Now, look, I'm mostly disappointed just because in the way that I know that the evidence was handled in this case.
Right.
And if it was going to be handled in such a way, it's even worse. It's made even worse just knowing that the judge has this gag order on the case where the attorneys have not yet, as far as I'm aware, they haven't lifted it. They can't even talk about anything yet, which is
I've never even heard of that. Have you? Where the gag order extends past the verdict?
The verdict? Not at all. Never, ever. Never. And then, not letting cameras in, not even letting transcripts out, or, just the secrecy in which this has all been conducted is troubling. And it's scary to think.
It's against our Constitution. It's not supposed to happen.
Yeah, I mean,
trials are supposed to be tried in the public, in sunlight, not in darkness and dampness and, under the eye of Judge Gull, who was clearly bias is not nearly strong enough a word, but it's the only one I can think of right now from the very beginning. Crooked. Yeah.
Nefarious.
Yeah. Corrupt.
Yeah. I guess the scary part is any one of you can be subject to something like that. And that's why we watch these cases. Oftentimes you put yourself in these cases yourself and you think about what you would do or say. What could Richard Allen have done different, man? Right. He wasn't confessing on day one. And they got him, why? Because of an unspent bullet that might fit in a gun that he owns?
Oh, but there was somebody else who was also, who was close to the scene, who lived right down like a few hundred yards away, whose testimony came into the trial, who happens to own the same gun of the same make.
It's like that Meet the Parents, Ben Stiller, when he's like, you don't think that the suitcase company, in an effort to make a profit, decided to make more than one suitcase? Yeah, maybe. Right. Possible. It's possible. I just, I don't know. My heart hurts for the families, most of all, because if I was Abby or Libby's parents, their dad or something, I'm not sure how I would feel about whether or not justice has been served in this case. And I have no idea what they're thinking. I don't know what they're feeling. I think that they would want to believe that Richard Allen was the guy and now he's been brought to justice. Nothing's going to bring back their daughters. But to the extent that maybe they have their own questions and that's the investigation that their daughters garnered, that was the best they could do. That's what we got.
And how cool is it? I was saying to one, I think Honey Bunny or Justice A through Z in chat here, we were texting earlier, and I was saying how cruel it is to the families to, probably regardless of what they have had thoughts about along the way about his innocence or guilt or their doubts, at this moment, they probably feel, at least temporarily, like the weight of the world was taken off their shoulders. Like this is no longer something they have to deal with. This is now in the past. They can move on and heal in whatever way they do. And what a cruel twist of fate it is for them to find out that their biggest battle may still perhaps be ahead because this case was not tried properly.
Well, I'll give you some insight. When I've done these jury trials, I've won trials, I've lost trials as a criminal defense attorney. And the trials that I've won without fail, it's like the defendant is there's always a lead up when they read the verdict. It's like, hey, you got to be like within 15 minutes of the courthouse at all times. They could call us at any time. And then it's like, oh, well, how long do you think it's going to take? I mean, they could be come back in 5 minutes. We could be here for like the next 3-4 days. And then you say that they think they have time because it's the illusion of time. And then they call you back in. The air is so heavy and they're walking. You don't even want to talk to them because it's like they're on pins and needles because they know that I might just be spending the next years of my life in this effing place. And the reality of that starts to set in. There's no more strategy. There's no more guessing. It's here. It's a verdict. You're guilty or you're not guilty. And you're either going to jail or you're going home. And then when the judge reads the verdict or the jury foreman or whatever, not guilty on count one, not guilty. It's like, oh my God. And then they start crying and then like they want to give you a big hug and it's like this huge release. And then I've seen it the other way. When you thought that your client was innocent and you put on the best trial that you possibly could and they read that verdict, guilty.
Oh God.
I've had a client literally throw up at the trial just because of the prospect of that. And it was a lightweight sentence. He was getting like 6 years. Well, we didn't know at the time. He was facing a lot longer, but he ended up getting sentenced to 6 years. But just the thought of, he really thought he was going home. I thought he was going home. Nope. Guilty. And the reality of that setting in, it was I can't imagine how Richard Allen is feeling. Can't imagine how his family feels, his defense attorneys, how they must feel. There's the one I've been taking up this for months now, over a year at least. Multiple attorneys on this case. It is, look, today is going to set in and tomorrow they're going to each feel a certain way. And they're both in for a ride. Even the families, they're going to go and what are they going to do? They're going to celebrate. And then tomorrow they're going to find out that a notice of appeal has been filed because of all of these appellate issues. And this isn't going to go away. It's going to be years. We're going to be talking about this case. And you could thank the investigation, really, and the way that the trial was forced to be done in secret in these private catacombs over there in Indiana. I don't know. But it's unfortunate. It sucks. And I think that this needs to sink in for those that have been following this case, because this is really mostly a reaction video to me and my initial F-word reaction to the verdict. And
I told you, I literally wept when I heard the verdict. I don't know if Casey Anthony verdict, I cried when I heard that too. I remember it so clearly. I was at my lunch hour, but yeah, I mean, and I wasn't expecting that. I knew I'd be upset because of all the issues of justice that are involved. Like I always say on my channel, and people say, oh, why even care about true crime? Well, we need to care about these issues. Like our law, our government, the prospect of our freedom relies on us caring and taking part in our system. And when we stop caring, that's the day when we no longer can have the expectation that if we ever need the law to, defend our rights, to give us our freedoms, to protect us, or whatever else it may be, we can no longer have that expectation. We're all expected to take part in the system.
And you know what? Most of the time you probably can have that expectation, but you just know that there's certain circles, there's certain situations where people will do you dirty. And if they want to, there's nothing that you can do to stop it. Let's just say that Richard Allen was not guilty. He's not the guy. He's been in jail for how long now, man?
2 years, a little over.
Life destroyed, marriage destroyed, and now he could expect to be there the rest of his life.
Yeah. Sanity destroyed. I mean,
oh, a long time ago. His sentence has been gone for a long time. Yeah.
Basically, if he was acquitted today and he walked out a free man, he's not really a free man. The demons that he will live with for the rest of his life that did not exist before he was arrested, you can't take those away. Yeah.
That's exactly right. And I don't know, man. I got to process. I need some time to process. I'm still processing. Yeah. Kelly, you're going to be doing your show at like 5 o'clock. I'm going to try to jump in.
8:30 Eastern time. So that's
I got a little bit of time.
Yeah, it's like a little over 2.5 hours from now. I'll start on time because I have a guest. So know that. People that expect me to be late, I'm not late when I have a guest.
I will jump in as early as I can for as long as I can.
Awesome. Thanks.
But thanks for coming on the show. It's been a pleasure to have you.
Yeah. Thanks for having me.
Yeah, we got to do, hey, you know what you really got to do? You got to do our Family Law After Dark shows.
I would love to. Yeah, you know what? I just have to, when's the next one coming up?
We always do on Fridays, usually at noon. It's like 3 o'clock
okay.
your
So
time.
Friday, so that's earlier. Yeah. And I sent you a text earlier if you can do Madeline Soto coming up soon. So
For sure. No, I got some stuff coming up on Soto case. Yeah, for sure. That's another one of the big
I
cases
have
we've
big
been
questions
following.
for you. Big questions. Yes, I will do.
Yeah.
I'll try to do that this weekend. What is it? Family Law After Dark, you said?
Yeah, it'll be this Friday.
Okay.
And we always have a lot of fun on that show. It's so not serious. Like, it's a very casual atmosphere.
Nice.
Most people come on the show, they have alcoholic beverage in hand.
Nice.
If you choose. Or
Cool.
you don't have to. It's
Sweet.
cool. All right. All right, everybody. I love you all. We will see you guys next time.
See you at 8:30 over on What's the Obsession with Omar.
Oh, if you haven't done so already, go subscribe to What's the Obsession. Go over and check out her live stream. She's also going to be covering the Delphi case tonight. And I'm going to be jumping in for a spell.
Awesome. Thanks, guys. Bye. Take care.
Bye-bye. All right.